Шановні учасники нашого заходу,
Dear
вітаю всіх. Прошу, будь
participants,
ласка,
our
займати свої
event,
місця.
I welcome you all.
Можливо, хтось іще не завершив
Please
свій
take your
сніданок,
seats.
спілкування.
Maybe you
Будь
have
ласка,
not
просимо до зали.
finalized your breakfast communication. Please, we
Прошу
invite you
також
into the room.
наших колег із нашого управління перевірити, можливо, люди нас не
We
чують.
ask
Запросити
colleagues
людей,
from our department,
колег до
please
зали, будь ласка.
invite all
Зараз
guests
хвильку ми
into the
починаємо.
room. We shall start in a moment.
Слухайте, така пауза, для мене така честь. Я не знаю, коли це був такий останній момент, щоб скільки в нас
There
було
is
голів,
such an honor for
нижчих
me.
інстанцій, колег,
I
суддів,
don't
гостей,
remember
експертів
such
таких
time
прекрасних.
that we had
Відчувається,
so
що,
many
мабуть,
top-level guests,
сьогоднішня
esteemed
тема
people.
не
Probably
наскільки кожну
today's
душу
topic
юриста, який не тільки в цьому залі
touches the
знаходиться,
heart
а
of
й
every
онлайн,
lawyer
зачепила дуже
in
глибоко.
this room, and not only.
Сьогодні будемо пробувати поговорити про ці всі
Therefore,
питання та
today we
проблеми.
shall start
Так, ну
discussing
що,
all
пані
those
Ірина
problems.
Кушнір, є вона? Чи можемо
Madam
розпочинати?
Irina
О,
Kushner is here.
можемо.
Can we
А
start?
я насамперед перед відкриттям подякую вам
First and
і скажу
foremost,
єдине,
I
що ми з
was
пані Іриною Кушнір
to
так
welcome
неформально
you all
домовились,
and
що
must
ми
say we have agreed with Irina
зробимо в
Kushner
дружній
informally.
атмосферній залі сьогодні наше
We
спілкування.
shall make
Можливо, це
communication
інколи
in
навіть
this
буде
room in a
виглядати трошки
friendly
менш
manner.
формально, до чого ми
Sometimes
звикли,
maybe it will
але
look
ми не стоїмо на
like
місці,
it's
і
not
ми
so formal
пробуємо
as we used to
рухатися
do,
вперед навіть в цих
but we
умовах
are
війни,
advancing
оскільки ми
even in
насамперед
the
люди, не тільки
conditions of
судді.
war.
І
We are
тому,
not only
шановні панове,
justices, we
пане
are
голово Верховного
human
суду,
beings. Esteemed
пане
ladies and
голово
gentlemen, esteemed
Конституційно-адміністративного суду,
President
у
Supreme
нас
Court,
ще є
head of
голова
the
касаційного
administrative,
господарського
so we
суду.
had also
Цивільного не
head of the
бачу, але
cassation commercial
колеги,
court, don't see colleague from
друзі,
civilian court.
наші міжнародні
Colleagues,
експерти,
friends,
які
our
онлайн,
international
гості, які
experts that
онлайн,
are online,
науковці
guests
і
who
просто
joined
небайдужі
online,
люди, які вболівають за
representatives
право,
of
за права
academia,
людини. Це
and
їх зал.
just
Вітаю
people
і оголошую сьогоднішній
that
захід
care
наш відкритим.
about this topic. I announce this
Для мене
event
велика
open.
честь
For me,
відкрити
it's great
уже
honor
четвертий
to open
наш
already
міжнародний
the fourth
семінар-практикум. Чи є
international
дієвим право людини
seminar-practicum.
без
Is
права на
it
його ефективний захист? Питання
is
відшкодування за
effective
порушених
the
права
right
внаслідок визнання
for
акта
effective
неконституційним.
protection
Насамперед повідомлю
as
вам трішки
the
про правила
result
безпеки,
of
яких ми
recognizing the act
маємо
unconstitutional.
дотримуватися.
First of all,
Мені
security
організатори повідомили,
announcement.
що якщо буде тривога,
Organizers said to me,
у
as
нас
soon
відповідно
as
будуть
air alert
на виході
starts,
стояти люди, які забезпечать нам супровід і проходження
there
в
will
безпечне
be
місце, тобто в укриття.
guards that will
Тому
help
я
you
не
to go
буду
down to a
витрачати
safe
час
place to
на ці
bomb
речі. Після
shelter.
повітряної тривоги, очевидно, що ми будемо
After
продовжувати,
the end
але поки буде
of
повітряна
air
пригода,
alarm, we shall continue. As long
ми не
as
позбавлені можливості з вами продовжити
air
спілкування.
alert
О,
is going
це
on,
що?
we shall not continue communication. So what's that? What have we seen?
Тривога?
Is that the alarm?
Можна подивитися, що там, будь ласка. Ми вирішимо, приймемо рішення, що ми далі
Now
робимо.
we shall specify and make a relevant decision.
У будь-якому випадку.
Anyway,
Ого.
oh gosh.
Пані Ірина,
Irina,
що там?
what's happening?
А що там? Що там?
What's happening there?
Яка інформація?
What information you received?
Ну, дивіться, тут, мабуть, мені потрібна допомога
Just,
залу.
look, I need
Наразі
assistance.
шахеди
You.
чи шахеди.
Shahed
Що ми робимо?
drones are flying.
Можливо, не долетять? Можливо, не долетять? Продовжуємо.
Shall we continue? Because there is a
Колеги,
possibility that these
що робимо?
Shahed drones will not
Продовжуємо. Пані Ірина?
reach here. Shall we continue? Irina, what's your opinion?
Ну там один, якщо один, да? Один шахет.
One
Один
shahed
шахет.
is
Ну,
flying.
може, він не долетить до Києва.
If there is a one shahed, there is possibility that it will be shot down before it reaches Kiev.
Дуже. Так, рухаємося. Тоді ми швиденько
Okay, so we
рухаємося,
shall
тому що це
continue
сьогодні може бути неодноразово.
quickly, because it may have myself. An air defense, we invite you to the bomb shelter.
Ну, за погодженням з залою і враховуючи, я мушу це
But
озвучити
with
для
your
наших
consent,
онлайн гостей і експертів, оскільки це
and I
шахет, то
announce
будемо
it
сподіватися,
over
що,
for
можливо, він
our
не долетить до
guests who
Києва,
are
власне.
online, we
Будемо
still
далі
hope
спостерігати,
that
як будуть
if it is one
розвиватися наші
shahed, it
безпекова
may not
ситуація
reach
в Києві,
Kiev,
і
and
залежно
we
від
shall
цього будемо
continue
мудрості приймати рішення.
watching
Для нас
security
буде зараз
situation in Kiev.
зупинятися, вже набираємо зараз темп,
So,
шановні колеги. От,
dear
єдине,
colleagues, no more
на що
introductory
я
words.
зверну увагу,
The
що
only
сьогоднішній
thing
захід
that
є
I want to pay
продовженням
attention
сесії
to that
тематичних семінарів,
today's
які розпочав
event
Конституційний
is the
адміністративний суд, зокрема,
continuation of the
продовжив
set
у
of
2019
seminars
році.
started
Ці
by
семінари
Cassation
були
Administrative
присвячені
40
реалізації
years ago.
Конституції в адміністративному
It was
судочинстві.
devoted
Йшлося про
to
вплив юридичних
realization
засобів,
of
визнання
Constitution in
нормативного акту
practical
неконституційним на захист прав людини, про
legal work.
застосування адміністративними
Use
судами
of
Конституції України як акта
Constitution
нормативної,
of
а також
Ukraine as a
про вирішення в умовах
direct
чинних справ з
action
дотриманням
act
конституційних
by the
вимог
court
щодо меж та обмежень прав людини.
and
Тому,
use of provisions
розпочинаючи
take
цей
into
захід,
account
я для вітального слова хочу
limitations of
запросити
human rights.
голову Верховного суду
I would
Станіслава
like to
Кравченка.
invite
Прошу, будь ласка, дякую.
President of Supreme Court Stanislav Kravchenko for welcoming address.
Доброго ранку, шановні
Good
колеги.
morning, dear colleagues.
Радий вітати вас
I'm
на
glad
цьому
to welcome you
міжнародному
all at this
семінарі-практикумі,
international
присвячений питанням відшкодування шкод
seminar
за порушення права
devoted
внаслідок
to
визнання актів
paying
неконституційними.
compensation
Приймається
for
підхід,
damage as a
наскільки це десь
result
можливо, щоб
of
бути що може
recognition
неформальний.
of an act as unconstitutional.
Важка ситуація, важка обстановка, важкий робочий тиждень.
Well,
Але я
talking
думаю,
officially, I
враховуючи
must
те, що
say,
закінчився у
situation
нас
is hard.
таким гарним заходом,
This working week
то
was very difficult, but the fact
принаймні, на мій
that in
погляд,
the
це дає
end of the
надію на
working
майбутнє,
week
бо
we have
якщо
such a
після
nice
трошки помовки ми
event,
говоримо
that gives us
про
hope for the
права
future.
людини, а ми їх не тільки
When
говоримо,
we discuss
реалізуємо
human rights, we are not
в
only
різних
discussing
практиці
them,
і
we are
юрисдикції
talking
Україна
about
це робить.
observance of human
То,
rights.
безперечно,
All
дуже
jurisdictions
такий
are doing
позитивний
it,
сигнал.
and that we are
І віра
doing
в
it
майбутнє,
during
що
the
у нас
war.
все
It's a
буде
very
гаразд.
positive signal, and this is
Що
a
на
hope
фоні
for the future
важких
that
ковід
everything
другої
will be
безпекової
okay.
ситуації
Of
речі
course,
справді
saying
виглядає
that
складно,
in the
але
time
я
of
вірю, що це
air
правда.
defense
І
alarm,
тому я щиро
well,
вдячний
it's
організаторам
difficult,
цього
but
заходу,
we shall overcome.
співорганізаторам,
I'm
саме проєктом
thankful to
Ради Європи,
organizers of
саме
this
підтримка судової влади
conference,
України в умовах війни та
to
післявоєнного
Council of
періоду,
Europe
посилення судових
project
та
of
позасудових
support of
засобів
the
захисту
judiciary in the
прав
war and
осіб,
post-war
постраждалих від війни в
period,
Україні, програмі
protection of
підтримки
rights
України
from
ОБСЄ,
suffered
підтримка
during war,
національних
OSCE
стейкхолдерів через покращення
project
доступу до
support of national
конституційної
stakeholders
юстиції,
through
а також
improvement
німецькому
of
фонду
access to
міжнародного правового
constitutional justice
співробітництва
and
за
German Fund of
організацію
International
проведення цього
Legal
заходу.
Cooperation for organization
Чому його
and
надзвичайна
holding this
важливість,
event.
чого ми можемо казати, що
Why
це,
this event is so
без сумніву,
significant? Why?
одне із
No
тих питань,
doubt,
яке ми
this is
можемо визначати
one of the
основним питанням
things
номер
that
один.
we can
Тому що в
define
сучасному
as
світі
issue
захист
number
прав
one.
людини – це
In
не лише
modern world,
декларація, а
protection
й
of human
обов'язок
rights is
кожної
not just a
демократичної
declaration,
держави.
but an obligation of
Це
every
важливо було
democratic
для
state.
України завжди,
That
важливо
was
і зараз.
always important for
І
Ukraine. And
Україна
important is
послідовна на
if
цьому шляху, як ви
now
знаєте, що з перших кроків,
much has been done on
як
this
ми
road.
здобули свою незалежність, це
As
питання
soon as
стало
Ukraine
номер один.
got
І практично
independence,
уже в
issue of
найближчому
human
році це
rights
було
became
формалізовано
issue
в
number
Конституції,
one.
яка була
Later, it
прийнята
was
в
formalized
96
in
році.
provisions of Ukraine
Зокрема, і
constitutions
визначення
adopted
статті
in
3 Конституції про те, що
1996,
права і
especially
свободи
Article
людини і
3.
гарантії
Rights and freedom
і
of persons,
забезпечення
their
це є головний
safeguards
обов'язок
and
держави.
observance is the main duty of the state.
Крім того,
Apart from that, Article 152 of the Constitution defines the possibility of compensation for the damage, especially if relevant legislative acts adopted in the state later are recognized as illegal and cancelled. But we all know just declaration of one norm is not enough. There should be effective mechanism for realization and for legal remedy. After making such powerful, nice steps, which start being implemented and reflected in civil code, in Article 111.75, damage caused to a person in case the act of state authorities is recognized as illegal, a person is entitled to indemnity. Although Constitution is effective for 28 years, constructive steps that were made initially are now suspended to an extent. What is damage? Damage could be material, it could be managed. Then the question how to define it in this and that case. What legal remedies can be used? Damage is compensated by renewal a person in position of the work. Recent example regarding High Qualification Commission of Judges. It was blocked for almost 4 years. Constitutional Court ruled that that norm of the law was unconstitutional, but it's not a possible restoration to restore these people into the positions that they had held 4 years ago. Can we say that damage can be compensated by realization of such a norm as paying salary for all previous period, plus indexation of monetary unit? Other important issue, indemnification of the damage in criminal proceeding. Yes, there is a basic law called on compensation of damage incurred to an individual as a result of unlawful actions of the court. And there are clear criteria regarding payment. But if we look at this basic law now, it doesn't look like it pertains to decisions of Constitutional Court. There is a sentence there when the proceeding is terminated.
Якраз про відносини в зв'язку з рішенням Конституційного суду, а не звичайною декриміналізацією.
If it is done in connection with the judgment of Constitutional Court, not because of usual decriminalization, many questions do arise.
How can we enforce those decisions? And since the basic norm that I quoted is about the state responsibility, so which subject within the state should be the respondent in these cases? Because when it comes to a public institution, it's not always the continuity that is in place, and there should be some financial discipline, and without specific targeted budget programs, you would spend the money on other needs rather than the ones provided for in the state budget law. So today we will be discussing all of those issues, and the Secretary of the Grand Chamber will be discussing it, and the issues of the division or separation of jurisdictions is very acute. The Grand Chamber vented its position quite recently that it's up to the administrative court Court to consider such cases, particularly given if the situation when the legal relations start in the administrative jurisdiction, so they should be completed there. We discussed that with our colleagues from the Administrative Cassation Court within the Supreme Court, and we speak about the compensation of damage due to unlawful dismissal. So we don't have any specific laws. We don't have the clear guidelines on how to act. And I hope that our legislators will be open and will listen to our opinion and respond to it. So when there is no law in the Ukrainian tradition, then we resort to the advice and wisdom of our international colleagues and of Ukrainians working for international institutions. We will hear from Mykola Gnatovsky, who is a judge of the ECTHR, and then we will hear from some Western European experts, and all together will enable us to decide whether we are moving in the right direction and what needs to be done in order to have these issues regulated at the level of national legislation, even though I see clearly that it should be addressed by lawmakers. So I would like to thank the organizers for bringing us together here for an important event, and I wish all of us a fruitful work.
Продовжуємо далі. Дякуємо, пане голово.
Great. Thank you very much, Chief Justice. I would like to ask the technical support to make sure that all of the mics at the tables are operational. This event has been prepared for 6 months, but it would have never taken place but for our reliable and powerful partners who, even under the circumstances, are prepared to support us, to share all of the hardships of the day and facilitate the organization of such events. So I will give the floor now to Ms. Irina Kushnir, Project Manager of the Council of Europe Project, Support of the Functioning of Justice and the War and Post-War Context in Ukraine. Irina is well known to all of us, and I'm sure that every colleague from the Supreme Court would be following and reading her post, her reviews of the ECTHR judgments, and she does a lot in the public domain, promoting the position of the Council of Europe and Ukrainian judiciary. Thank you very much, esteemed Chief Justice of the Supreme Court, Chief Justices of Cassation Courts, members of the judiciary, esteemed partners from OEC, SPU, thank you very much for finding the time to join us in this polycameral event dedicated to the main issue, that is, whether the fundamental rights are properly protected when it comes to the constitutional rights. Speaking about the constitutional rights and freedoms, we are speaking about the abiding by the European Convention, because all of those rights should be seen similarly, interpreted similarly, and protected and promoted similarly, according according to the CHR standards. Ukraine is unique in that in its evolvement of abidance by the standards of the Council of Europe and the European Convention, we had to move very rapidly. But when we acceded to the Convention, to the Council of Europe, the case law of the European Court of Human Rights and the Convention standards were already in place. So we had to deteriorate that, to adopt and adapt it, and start implementing all of the provisions immediately. And we know the case law against Ukraine that testifies to the thorny path that Ukraine has been going through at this stage of the convention implementation. I'm sure that the next stage would be the implementation of the EU legal standards, and we will face new challenges yet. So we need to address the issues with effective protection of constitutional rights and liberties right now, as matters stand, including the rights guaranteed by the European Convention. And then we should be passing to the next stage, the stage of European integration. Now, speaking about proper protection of the rights with a view to implementing the European Convention, we should focus on efficiency and effectiveness. We don't need the Constitutional Court rulings that would not be properly enforced. And the compensation of damage, the indemnification is a very challenging task. It is related to the effectiveness of the rights protection and a balance. That's the next category that we should be discussing at this platform. The striking of a balance is important because while we aspire to ensure the proper and effective protection of rights and focusing on an individual and individual complaints, we might violate or break this balance and forget everything about the societal interests. But those have to be taken into account as well. I'm thankful to the Supreme Court for inviting us to support this event. It is extremely important for the Council of Europe and for our project. Today, while discussing the issues on the agenda, I hope that you will be most engaged. You will make this discussion of high quality, and then there would be very practical takeaways. And the Supreme Court and the Council of Europe will find support in implementing the recommendations of this discussion. Today with us we have international expert Slavica Banic, who's the international consultant and retired judge of the Constitutional Court of Ukraine. We also have our colleagues, my colleague Natovsky Pavlo Pushkar. We've got Rimvidas Norkas with us, who is judge of the General Court of the European Union until 2024. And the next steps will hinge on the efficiency of our work today, effectiveness of this work. All of you are encouraged to raise your hands and to engage in the overall discussion. And then we will be noting all of your proposals and then act on them accordingly. Thank you, Irina. Irina said that, and I will be reminding you about these rules. We've planned to publish a thematic collection of articles. We have already published one, and that collection of works was very popular, and Albert Yezerev then developed the ideas, and he and his colleagues even published a whole monograph. So those who who want to contribute, you have an opportunity to do so. So you will be able to contribute not only to this discussion today, but also to the publication afterwards. And now I would like to give the floor to Mr. Alexander Vodyadnikov, who is Senior Project Associate, OEC Support Program for Ukraine. So please keep within 3 minutes, will you? Yes, of course, I will keep within the time allocated to me. Esteemed Chief Justice of the Supreme Court, esteemed Chief Justices of the Cassation Court of the Supreme Court, our colleagues from the Council of Europe, international experts, dear friends, I would like to welcome you on behalf of the OEC SPU. It is great pleasure for me to speak after Stanislav and Irina here, because they have made certain accents as to what is to be discussed today. I think that the damage in public law is different from that in private law, and that affects the issues of balance. The next thing that I would like to underscore is the right to the constitutional complaint that was introduced back in 2016 is not just within the purview of the Constitutional Court, but it is a constitutional right enshrined by Article 55, so it should enjoy all the guarantees that other constitutional rights have, including the right to fair trial. And the very last point that I would like to make is that the issue of the effectiveness of the constitutional rights and freedoms and the effectiveness of their protection depends on professional collaboration and interaction amongst the general jurisdiction courts and the Supreme Court, because the Constitutional Court forms the case law and its positions, and the legislation does provide for such collaboration, and Article 55 of the law on the Constitutional Court allows the Constitutional Court to collaborate with other courts who seek explanation on the part of the Constitutional Court. And yet, I would like to raise another issue. Mr. Kravchenko has mentioned the legislative gap, so to say, in the procedures for the compensation of this damage. The question is whether this procedure can be regulated by the law. And on behalf of the OEC SPU, I would like to thank all of our partners from the Supreme Court, from the Council of Europe, for the fruitful cooperation that we've historically had over these years. Thank you very much, and have good and fruitful cooperation and discussions.
Керівниця проекту в Україні та В'єтнамі Німецького фонду міжнародного правового співробітництва.
Of the Ukraine project of German Foundation for International Legal Cooperation. Can you hear interpretation?
Yes, I can hear. And you can hear me?
Так.
Yes.
Yeah, okay. Can I start? Okay. Okay.
Yes, interpreter can hear you.
Yeah, thank you. So, good morning, dear Chief Justice of the Supreme Court, Mr. Kravchenko, dear Chief Justice of the Administrative Cassation Court, Mr. Smokovich, dear Mrs. Bilak, Judge at the Administrative Cassation Court, dear Mrs. Kushnir, dear Mr. Vodyadnikov, dear judges, dear ladies and gentlemen. On behalf of the German Foundation for International Legal Cooperation, I thank you for inviting IAZ to take part again in this roundtable to discuss actual topics related to the administrative court case law. I would like to express our greatest appreciation to you how unwaveringly the Ukrainian judiciary continues the jurisdiction even under the most difficult wartime conditions, and also maintains its international professional contacts like today's conference. We have a long-standing working relationship with the Constitutional Court and the Supreme Court. Therefore, I'm glad that IAZ will receive Mr. President Kravchenko with a delegation of the Supreme Court in 10 days in Germany. Our cooperation also includes the Administrative Cassation Court and the complete Ukrainian administrative jurisdiction to a most productive and efficient extent. Today, IAZ delegates a speaker for session 2, in which Martin Steinkühler, judge at the Federal Administrative Court, takes up the topic of retroactive effects judgments of the Constitutional Court. Martin Steinkühler has gained plenty of experience in the German administrative jurisdiction, and he is a judge at the Federal Administration Court for more than 10 years. As a proven IAZ expert, he has been in contact with the Ukrainian colleagues for a long time, be it in Ukraine or in Leipzig. His participation will enrich the conference, I'm quite sure. Now I wish all of us a successful conference. Thank you for your attention.
Пані Шманк, щиро дякуємо вам за ваші натхненні слова. Ну і нарешті я запрошую, кожен раз я це повторюю, лідера, по-справжньому лідера, людина, яка по-справжньому
invite now a leader of administrative justice, who is a real leader, because he will tell us how constitutional justice is used in the field of administrative justice. Михайло Смокович. Good morning, dear participants of our practical seminar. I welcome the heads of the courts. I welcome international experts that joined us online, the judges and justices especially. I'm thankful to presidents of courts who arrived from near border areas, Odessa, Zaporizhia, Dnipropetrovsk, Kharkiv, Sumy, and others. Thank you very much indeed for that. That proves that despite everything, we continue exercising justice. We fulfill the constitutional function that cannot be stopped during the martial law time. The topic of today's seminar is quite needed. I'm a judge for 28 years. Our constitution is also 28 years old. I have never seen a single court judgment, as Stanislav Kravchenko said, that someone was damaged by the state for unconstitutional action. Thank you for that. We were pioneering that. We must move it forward and continue doing our work. I thank all presenters that made welcoming address before me. Thanks Stanislav Kravchenko, who is promoting our courts to European Union, to Europe. Well, still countries may be not exceeded, but with our court activities we are already in Europe. So, thank you, Miroslava, not for we are doing, but what has been done. All that is written in convention, all that is written in constitution, but it is not practically implemented, it is dead. Thank you for access to public information. Thank you for this event. Thank you for doing all that you are doing for us. Thank Alexander. He was a member of Constitutional Commission supporting administrative justice, stood for norms in the Constitution. We made them not for nothing. We wanted administrative courts be real independent. Thank Angela, German Foundation that is permanently supporting us. Thank you all indeed. The topic of today's seminar is real significant and relevant. I know that many issues will be discussed. Maybe we shall finally come to the conclusion that all should be done by constitutional court. It's the constitutional court who must compensate for the damage. Because all these norms are there. What for? We should do it. But we shall make a final say. It's not a conference, it's a seminar. Please be active. Thank you very much.
Мені приємно.
I am pleased. Now,
І тепер до запрошується наш гостьовий спікер.
hear all these introductory speeches, but now I invite a guest speaker. But it is a special guest speaker. Madam Alexandra Matviichuk is a missionary. She is a human rights activist, Nobel Peace Prize laureate. We shall get her video address, specially recorded for our event.
Мене звати Олександра Матвійчук.
Alexandra Matviichuk. I am human rights activist. For me, it's a great honor to address such esteemed audience. I am documenting war crimes in the war that Russia started against Ukraine. My partners and me have created the national network of documentators covering entire Ukraine, including occupied territories. In 2.5 years of full-fledged invasion, by joining efforts, we have documented more than 80,000 episodes of war crimes. Sometimes people who suffered ask me, why that happened? Why that happened just with me? And how shall I live now? But much more often people ask, why the law is not functioning. While entire international system of peace and security of United Nations cannot stop Russia's atrocities. Therefore, I know that millions of people touched by the war need restoration not only of their ruined life, family, vision of the future, but restoration of their belief that justice does exist. Maybe it is possible in time. I also know that people see justice differently. For some people, justice is when a perpetrator gets behind bars. For some, justice means possibility to get compensation for the damage incurred. And without that, they will think that their rights are not restored. For some of them, justice is just the possibility to get to know the truth, what happened to their close loved ones. For others, justice means just the possibility to be heard and to get official recognition that what has happened with them and their families is not just immoral, but also is unlawful. Therefore, the role of courts in this historic period, without any exaggeration, is one of the most significant. Where the state of Ukraine has control, the state of Ukraine must bring back to people this feeling of justice, and then people will fight for the state, each and every, in his or her place. I understand that administering justice under Russian bombs is a resistance act, but just these actions help people to restore belief in values for which we are all fighting. It's just the values, not formal declarations or written strategies, define actions and decisions by millions of people, and as a result of that, survival of our state.
Дякую.
Thank you.
Дійсно,
It's
як
true.
наголосила пані Олександра, робота
As
судів у цих
Alexander mentioned, the work of the courts in these conditions help to restore
за які
belief of people into values that we are fighting for. There is no right without remedy is a preliminary conditions for exercising justice. If we have the right, there is a remedy for protection of this right. In case a human right is violated, there should be a possibility for a person to go into court and get the rights restored. In historical aspect, this principle goes back to the Roman law, where provision of remedies for protection of violated rights was the main principle of justice. With time, it became legal in the works of Sir Edward Cook, English Justice and Practice, a historian, author of the work on general law, commentaries on the laws of England. In this work, Blackstone emphasized that every legal right must have protective remedies. Where is the right? There is the remedy. It is in line of the principle introduced. They became universal the world over. In European continent in particular, due to the Statute of Council of Europe that Ukraine has acceded. In modern application, this principle remains a cornerstone in modern judicial system, ensures existence of mechanism for protection of human rights, ensuring the mechanism of compensation of the damage as a result of recognizing law of unconstitutional is the balance between the rights of an individual and functioning of state legal system. Today we heard from our speakers in their introductory speeches and from President Kravchenko that it would be good if we could have a clear law and then all the issues would be removed. But nowadays, many problems still remain, in particular issues how to compensate for the damage caused by unconstitutional act. We don't have clear mechanism, we don't have clear regulation, and we shall discuss it today, in particular what is written in Part 3 of Article 170 Constitution. The issue is not only lack of understanding of this norm of Constitution, whether Supreme Court can use this provision. Part 3 of Article 152 of Constitution is the basis for going to the court, or it is only in the constitutional sphere. And the Constitutional Court, in its judgment, must indicate that and order courts to compensate for the damage. Can Constitutional Court do it by itself, or it's the legislator who regulates it? Should Supreme Court, together with lower level courts, to care about it, take into account Article 300 of Constitution of Ukraine that regulates work of Constitutional Court? Should the court be so dependent on decision of Constitutional Court if are not deprived of the right to review the judgments based on new circumstances, in which cases the state must be obliged to compensate for damage for approval of unconstitutional legislation. The law is constitutional and later it is recognized as unconstitutional. Can we believe that such legislation was adopted unfairly, whether there was abuse of power? When Constitutional Court itself rules that compensation should be provided, but what to do if you go to Constitutional Court with constitutional complaint?
І ці питання, вони
All these
породжені
issues
практикою
arise as a result of case law and real cases that do come to courts of various jurisdictions. Therefore, searching for answers to all of these questions, we will be holding discussions in session 1 called The Mechanism of Judicial Compensation by the State in accordance with the third part of Article 152 of the Constitution, the exchange of international practices. And I will give the floor to Mykola Gnatovsky, Judge of the European Court of Human Rights, PhD in law. Thank you, Miroslava. Thank you for the invitation to take part in this extremely important event. I would like to greet Chief Justice Kravchenko, dear colleagues from the Council of Europe, OEC, our German partners, experts from other European countries, Ukrainian members of the judiciary. I would like to raise the issues and to try to find certain answers to them from the perspective of the ECTHR, or at least those matters that are important for the court. I have got very little time, but still I hope that later I will be able to contribute to the general discussion. My brief intervention will be divided into 2 parts. The first will be about the question why these issues are important from the perspective of the European Court of Human Rights. And the other one would be the case law in a comparative aspect when it comes to the procedures and mechanisms of compensation for the violation of an individual's constitutional rights. Why is it important for the ECTHR? It is important from the logics of the convention, from principle of subsidiarity, according to which the main responsibility for protecting and promoting human rights and for ensuring compensation once they are violated lies with the state. And this is a logical conclusion from the preamble and Article 1 of the convention. And the European Court of Human Rights also has a separate article dedicated to the right to effective remedy. It's Article 13 of the Convention, the violation of which is usually found in conjunction with another right violated by the state, but it is a prerequisite for observing human rights. From the ECTHR perspective, the availability of the compensation mechanisms is very important while deciding whether the national remedy that should be exhausted before the applicant can go to the European Court, Article 35 of the Convention. And when the court assesses whether the constitutional complaint is an effective remedy, it assesses, amongst other things, whether the consideration of this complaint was linked to the mechanism of compensation for the violation of their constitutional rights. If this mechanism is not operative, then the constitutional complaint would not be an effective remedy. And that will mean that it doesn't operate at the national level. Similarly, these issues are important for the court in the light of Article 41, that is for fair satisfaction. That is when the court can award this compensation. But Article 41 links this opportunity to the availability at the national level of the compensation mechanisms. And I have to say that the second part of my intervention, and I won't conceal it from you, is linked to my work
внутрішніх, так би мовити, робочих механізмів суду над
in
деякими
the
питаннями
court on certain issues of improving case law related to Article 41 when it comes to the correlation of the judgments on compensation that the court approves with the available national mechanisms. Hence, of late, I've studied in great detail the national case law of various countries that are parties to the convention, and I will share with you the findings of this comparative analysis. I would also say that these issues are important from the perspective of Article 46, that is the force of the ECTHR judgments and how countries have to remove the violations established by the court. And the main principle is that the right should be reinstated, that is restituta should be an ideal mechanism, and where it is not possible or not possible in full, then we should be speaking about certain compensation mechanism. And the guidelines can be given as part of Article 46 in the ECTHR judgments. So how is it addressed by various European countries? Very briefly, the findings of this extended comparative analysis that I've conducted of late, as I said. I'll start with agreeing with Ms. Irina Kushnir in that the rights that are guaranteed by the European Convention are the constitutional rights in effect. These are the fundamental rights and freedoms that are enshrined in almost every European constitution. That's why the compensation issues, particularly when those constitutional rights are violated at the national level, addresses the issue of compensations and the availability of this violation of the rights enshrined in the European Convention. So these are very closely linked. In all European countries, including Ukraine, of course, at least at the theoretical level, there is an opportunity to file an action or file a complaint or in any other way to seek protection of the violated rights. It is about going to national courts or national administrative authorities. And here one should divide the available mechanisms into several areas. For one thing, there is an opportunity to apply to courts seeking compensation of damage in the spirit of what is envisioned by Article 1185 of the Civil Code of Ukraine, and there are special mechanisms when it comes to special human rights, because these violations might be widespread, and there are compensation mechanisms due to the constitutional complaints being filed. So these three various areas would be the topic of my further talk. In the overwhelming majority of the European countries, there is an opportunity through the court to establish the fact of violation of human rights and freedoms, and then ensure that the damage is compensated, material and moral damage, that is to say, or losses borne by the applicant because of the compensation say complaint procedure. As I said, most of the European countries do that, but there are various approaches. For example, the scope of powers depends on the national context and legal framework. Mostly it's part of the overall civil legislation or civil law, as in Ukraine, or on special provisions about the responsibility of the state for illegal acts or actions of the public authorities. then claims to general courts pertain to all types of damage compensation. In Armenia, for example, you can only claim compensation of moral damage. In Sweden, there is a separate procedure according to which you cannot make the public authority that is not party if in the case liable when it comes to the compensation. So there are nuances, of course, but by and large, this procedure is in place. Whether it is effective and whether the general legislation is sufficient is another matter. One of the options that is fairly efficient, at least I find it efficient, when a country has a specialized law on the compensation on damage caused by the state in violation of human rights or specific rights enshrined in the national law. Like specialized procedure pertaining to specific human rights when the issue is typical, systematic, and then the compensation mechanisms are put in place to compensate for the violation of this very right. The classical is the lengthy judicial procedures, and that's a regular problem for Ukraine, and this problem applies to Finland, Germany, even Greece, Hungary, the Netherlands, Poland, Serbia, Slovenia, lots of the countries that have issues with the time frames, and they've got the special mechanisms for compensation of the failure to ensure the observance of this right. The same pertains to the situations when the country has inappropriate conditions for detention in Hungary, Romania, Italy, and the issue on setting up such a mechanism is also topical for Ukraine. At least in the case Sukhachov versus Ukraine, this issue has been raised. There are certain laws akin to our law on the compensation for ungrounded conviction or detention. In Macedonia, for example, there is a similar law, but I'm not sure and can't say that these laws are fairly effective. Now, when it comes to the constitutional complaints, in Bosnia and Croatia, and I see that esteemed colleague from Croatia, Ms. Bunic, is with us, and she will share the Croatian experience better, but Croatia is one of those. The Czech Republic, Germany, of course, Montenegro, Northern Macedonia, Malta, Slovakia, they have specialized constitutional proceedings to reinstate the violated fundamental rights and freedoms. In Bosnia, Croatia, Malta, Serbia, and Slovakia, the compensations for the material and moral damage can be awarded by the Constitutional Court within those proceedings. In the Czech Republic, you have to go to the General Jurisdiction Court, but it will be guided by the judgment of the Constitutional Court. In Germany, the Federal Constitutional Court, in the case of the constitutional complaint, will rescind the unlawful decision, and there are rare cases when the Constitutional Court will award the compensation, but usually it is done by the General Jurisdiction Courts.
Все залежить від вибору національного законодавця. Щодо умов для отримання компенсації,
то mechanism choice depends on national legislation. As a rule, you must use general approaches to delict claims. As a rule, they are all quite typical. While concluding, I would like to say how to resolve this issue is the choice of national legislator and the choice of judges, how they formulate practice. European Court cannot dictate how to do it. One should do it the way it is working. I think that within today's discussion, we shall get this response. Thank you very much for your
Пане
attention.
Миколо, щиро дякуємо.
Thank
Я,
you.
колеги, перепрошую, я не буду робити ніяких відміток
that.
лише слів. Рухаємося, бо ми вже
Sorry, colleagues, I will not make any comments. Better we leave time for general discussion. I shall invite Микола Козюбра, Professor of Department of General Theoretical Law and Public Law of Kyiv-Mogil Academy, retired judge of the Constitutional Court, member of Council at Supreme Court, Doctor of Law, and my teacher, my professor.
Шановні учасники семінару,
Dear participants of the seminar,
ну, по-перше, добрий день, дійсно.
first of all, good
Я
afternoon.
почну з того, що питання, яке
I will
винесено
start
на обговорення
from
семінару,
saying that the topic that we are discussing at the seminar is not
тим
easy
більше
at
воно
all.
ускладнюється в
It's
умовах
given
війни,
even more
коли
complicated in
відчувається брак
conditions of
коштів
war,
в державі,
when there is shortage of
зокрема,
funds
тих
in the state
бюджетних
budget,
коштів, за рахунок яких держава має
and
відшкодовувати збитки,
the issue is
завдані
budgetary
актами,
funds
що визнані
used for
неконституційними.
compensation of damages for the acts
Питань
that
справді
are
багато.
unconstitutional.
Ті ж питання, які
Numerous
поставила
questions
пані
remain.
Мирослава,
Miroslava raised
відверто кажучи,
many of
з
them.
точки зору
Honestly
європейських
speaking, from the
стандартів
point of view
і
of European
традицій,
standards and
ну, принаймні,
traditions,
деяких з них точно б відпали.
some of them surely
тому,
will be dropped off.
Зважаючи на те, що
Therefore,
ми справді
taking into account the fact
і
that we are
сподіваємося,
still
що ми досягнемо цієї
moving
мети,
ahead, and I hope
до
very much
угоди
that we shall
Європейського Союзу,
achieve accession to
звичайно, ми
European
маємо
Union.
При вирішенні цих непростих
When
питань
resolving these uneasy
керуватися
questions,
насамперед
we must be
європейськими
guided,
підходами,
first of all, by
європейськими
European
стандартами
approaches,
звичайно,
European standards,
з
and of
урахуванням
course,
положень
taking into
Конституції і
account the
національного
provisions of
законодавства.
constitutions and national
Умов
legislation
війни
of Ukraine. In
питання
conditions of
справедливості
war,
загострюється.
the issue
І
of
справді,
justice becomes
при
especially
всій
acute,
складності
with all
знаходження коштів
difficulties
на відшкодування
of
збитків,
looking for funds
заподіяних
to compensate for
неконституційними
damages made
рішеннями,
by unconstitutional decisions,
неконституційними актами, які
unconstitutional acts,
вони, звичайно, тим більше вимагають звернення до відповідних
great
принципів,
extent,
закріплених у
demand
Конституції,
us
принципів
to
верховенства
take into
права,
account
зокрема,
principles
і принципу
enshrined in
легітимних
Constitution,
очікувань
rule of law,
від держави, що держава
legitimate
обіцяє, вона має
expectation of an
виконувати.
individual from the state. The state
Звідси
promised us, it
випливають
must implement.
концептуальні питання
Hence,
підходів
conceptual
до
issues
цієї
arise.
проблеми
How to
непростої,
approach this uneasy
які,
problem.
на мій погляд, мають, звичайно, ґрунтуватися і на досвіді
And these solutions
інших
must be
європейських
based
країн,
on
досвіді
experience of
Європейського
other
суду
European
з прав людини, і
countries,
насамперед
European Court of Human
на
Rights,
ґрунтуватися на
and first
Конституції України.
and
Так
foremost,
от, якщо
get
говорити
oriented
про
at
ці
Constitution of
концептуальні
Ukraine.
засади,
When talking
то
of
відправною з них
conceptual foundation,
має
the
бути,
starting
звичайно,
point must
стаття
be
3
Article
Конституції
3 of
України,
Constitution
про
of
яку
Ukraine,
згадував уже тут Станіслав
mentioned
Іванович,
here by
дійсно,
Stanislav
і яка
Kravchenko,
говорить про те, що
that says
права і свободи
human
людини
rights
та
and
їх
freedoms
гарантії
and their guarantees
визначають зміст і
determine the
спрямованість
content and
діяльності
direction
держави.
of the
Держава
state
відповідає
activities.
перед
The state
людиною
is
за
accountable to
свою
the individual
діяльність,
for its activities,
утвердження і
and the
забезпечення прав і свобод людини
establishment
є
and maintenance
головним
of human rights and
обов'язком
freedoms is the
держави.
main duty of the
Інколи
state.
наші
Sometimes
навіть представники науки
even
юридичні
our
вважають, що це декларація.
academic experts
Я
believe
сказав,
that
що
it is
дійсно
just
це,
a
ще раз
declaration.
нагадую, це базова відправна
I want to
позиція,
remind you that this is
яка
a basic
справді
starting
вимагає
point
не
that
тлумачення
requires
обмеженого, від чого
not
застерігає, як правило,
limited interpretation
Європейський суд з
that
прав
European
людини,
Court
коли
of
мова
Human
йде
Rights
про захист
always
прав людини, а вимагає
warns you against
тлумачення, я б не
when
сказав,
defending human
навіть
rights.
розширеного,
It requires, if not extended interpretation, but just the interpretation that is included into this provision. First of all, it follows from this provision that the gaps, collisions, uncertainties in the laws and other legal acts cannot become an obstacle for protection of human rights and freedoms and their restoration in case of violation, regardless of who violated them, including the state and its bodies. And secondly, the provision that the state is responsible to the individual for its activities means that it bears not only political and moral responsibility for its action, as some people try to interpret in this article, but also legal, retrospective responsibility in case of violation of human rights and freedoms by it or its body. Hence, next conclusion follows: the absence in the law of the appropriate procedure, mechanism for the restoration of a violated right, although to some extent it complicates its restoration. According to Ukraine Constitution, cannot become an unsurmountable obstacle to such restoration. A human right, I want to emphasize this, without the right to its effective protection, which is primarily judicial protection. Not all of us are used to it. This is a European tradition. To a great extent, it is caused by system of common law, the American law, but it is accepted by entire Europe. The right, human right, without effective protection, it not only ceases to be an effective right, it loses the quality of a subjective right as a legal category. The right without judicial protection stops being a legal category. It can be a moral category, but not legal one. And that should be taken into account as well. That means that material or moral damage caused to individuals or legal entities by acts and actions declared unconstitutional Part 3 of Article 152 of the Constitution of Ukraine must be compensated, despite the fact that there is currently no law establishing the procedure for compensation. Despite repeated reminders of constitutional courts, Верховна Рада of Ukraine has not adopted it until now. When talking about Article 152 of the Constitution of Ukraine, some people interpret it that between Part 2 and Part 3 of this article there are certain contradictions. Me personally, I don't see such contradictions. And I don't think that there should be some kind of retroactive action of judgments of Constitutional Court. Part 2 of the Constitution article focuses attention at the moment when certain laws or acts or their provisions are recognized unconstitutional. That moment happens since the day Constitutional Court makes its judgment about their unconstitutionality, if otherwise is not established by the judgment of Constitutional Court. Constitutional Court of Ukraine, after making judge about their unconstitutionality, in fact, changes normative regulations of relations. It acts as a negative legislator, one should say.
Тобто поширює його дії на ті
means
правовідносини, які матимуть місце після
action covers
ухвалення такого рішення.
such relations that will happen after this decision is taken. New legal relations are meant, but it covers also for the proceeding circumstances that happen after decision of Constitutional Court. As regards the reactive force, as far as I understand, there should be special presentation on that during this seminar. But in our case, this does not pertain to it. But 3 of the mentioned articles emphasize the duty of the state to compensate for the damage incurred by the acts declared unconstitutional before they become invalid, which is quite logical in my view. The basis for the court's decision on that issue is the provision of Part 2 of Article 8 of the Constitution of Ukraine, which provides that its provisions are directly applicable and guarantees the right to apply to the court for the protection of constitutional rights and freedom directly on the basis of the Constitution. As regards regulatory procedures and mechanisms, despite the fact that there is no law, regulatory framework that should be used here could be further developed. There is not only Article 56 of the Constitution mentioned here, but there is a special chapter devoted to it in the Civil Code, Ukraine, in particular, Chapter 82 of the Civil Code and Articles 1175 of the Code specifically deals with compensation for damage caused by a regulatory act that has been declared unlawful. Code administrative procedure also contains it. Probably all that is not enough, but under any circumstances, one can find a way out of the situation. And the task of the court is to find these possibilities. Otherwise, reference to the absence of the law on procedure of compensation for damage, and because of that, to refuse to open proceedings. In my view, this is refusal to exercise justice. And the practice of many foreign countries and case law of European Court of Human Rights stand on that. Despite certain difficulties, you can find a way out of the situation, and one should find it.
Під час провадження у справах про відшкодування шкоди, завданої
proceedings related to the compensation of damage caused to individuals or legal entities by the acts deemed unconstitutional are useful argument, not only before the European Court of Human Rights that Mr. Gnatovsky or Judge Gnatovsky mentioned, also there are a lot of judgments by the Constitutional Court of Ukraine. I used to Even though I wasn't the justice of the Constitutional Court, I still used to follow the judgments of the Constitutional Court when it came to the gaps in legislation. And one should recognize that the Constitutional Court case law has been fairly controversial. Any gap in the legislation according to that case law was to be addressed by the Верховна Рада, that's Parliament of Ukraine. But sometime later, under the effect of the decisions of some of other constitutional courts, in particular that of Moldova, the court shared a position whereby the gap in the legislation, if it makes it impossible to exercise the Constitutional Court, should be deemed unconstitutional. And the human rights that resulted from that gap should be reinstated. And I think those rulings were extremely progressive and fully in line with the judgments of the European Court of Human Rights. To a certain extent, it is a challenge, but on the other hand, we are thus learning to overcome certain barriers in recognizing that there are gaps in legislation and relevant acts of legislation should be deemed unconstitutional. And the ECTHR case law testifies that under any circumstances, the lack of a procedure should be compensated by referring to other articles in the Civil Code and some other laws. So this issue arises in the process of the compensation of damage caused by unconstitutional acts or actions is persistent. I won't call you the exact judgments related to this issue, but the motives that make the Constitutional Court deem a certain act unconstitutional can be substantive or they can be procedural. And these motives, of course, can affect the decisions of administrative and civil courts when it comes to the damage compensation. These are important issues, even though in each specific case, these motives should be well weighed. Another thing that, particularly in the conditions of war, we should keep in mind, and a general court should keep in mind, even though administrative courts are not viewed as general jurisdiction courts in Ukraine. So under the conditions of war, with shortages of funds in the state budget, we have to use the articles of the Administrative Procedural Code on the deferral or delay with the enforcement of certain court decisions. And I think we should resort to this measure more frequently than in peacetime. And the issues raised by the previous speakers and by Miroslava can arise from time to time, but we shouldn't rely on the academia that they will come up with solutions, say one-size-fits-all solutions, because every case is unique in and of itself. Even sometimes when they seem to be similar or even identical, in real life, circumstances vary. So every case is unique. That's why judges should exercise their wisdom, their good judgment and creativity. So I would wish the administrative courts to be firmly on the positions of the European standards and the Constitution, and be creative in looking for solutions that would be, on the one hand, in line with the people's demand for justice, and on the other, would not run counter to the European approaches. Thank you very much.
Я пропоную Миколі Івановичу пройти, бо у нас буде дискусія, щоб відразу...
Thank you very much, Mr. Kozubra. If you could sit here in the panel, because we are going to have a Q&A session at the end. And I would like to give the floor to Mr. Yuri Kryuchkovsky, Associate Professor of the Department of General Theoretical Jurisprudence and Public Law of the National University Kyiv-Mohyla Academy, member of this Research Advisory Board of the Supreme Court. Thank you very much. I would like to thank the organizers of this event for this opportunity to share my ideas. Lately, I haven't had the opportunity to talk to Mr. Kozubra, and I didn't know what he was going to discuss. But here I do agree that the issue of the protection of the rights violated by unconstitutional acts is a complicated voice. So among the constituent principles of the rule of law, the principle of respect for human rights and freedoms is a fundamental requirement enshrined in Article 3 of the Constitution as the main duty of the state. Then there is the supremacy of the Constitution and the Constituent Act of the highest legal force, Article 8 of the Constitution, that requires for all laws and other regulatory acts to comply with the Constitution, that is, to be lawful. Then the principle of legality, which refers not only to the requirement to comply with the letter of the law, but also to be legal in nature. The country where there is supremacy of the rule of law, there is also a principle of legal certainty, and it includes the principle of res judicata, which is very topical today. These principles are directly relevant to the discussion of the protection of the right violated by the application of the Constitutional Court. However, they should be borne in mind that the principles of law may come in conflict with each other, which is resolved by mutual agreement through comparison of the meaning in specific circumstances. Such a conflict between the above four principles does occur in connection with the issue under discussion. So Article 152 of the Constitution establishes the obligation by the state to compensate for material and moral damage caused to a person by acts and actions that are recognized as unconstitutional. I will underscore it. Thus, the compensation is not linked to the loss of such acts' validity. it doesn't mean that the act is no longer valid. Since the loss of the force occurs after the Constitutional Court of Ukraine recognizes it unconstitutional, such damage must have occurred before the unconstitutionality has been established. Therefore, Article 152 of the Constitution requires compensation for the damage caused in a manner that is considered to be retroactive. In order to assess the temporal effects of the SSU decision, it's fundamental to recognize that the main content of such a decision is the recognition of the fact of unconstitutionality, and the loss of effect of such act is a subsidiary consequence of the main content of the decision, which occurs by virtue of Part 1 of Article 152. So it's necessary to distinguish between the time when the effect of the unconstitutionality of an act is recognized, on the one hand, and the time when such an act becomes invalid, ex nunc or pro futuro, and finally the time when the act became unconstitutional. So, thus, the courts cannot be using this act anymore. So the time when the act became unconstitutional is important because it should be recognized that the act did not become unconstitutional as a result of the Constitutional Court decision, which only reveals and recognizes the fact of unconstitutionality. Therefore, such an act was objectively unconstitutional before. This does not mean that the SSU decision is retroactive, since the fact of unconstitutionality of the act was not created but only revealed by such a decision. This implied that obligation to compensate for the compensation of the application contrary to the statement about the allegedly retroactive effect of the Constitutional Court decision. So I think that this should be resolved to the benefit of Article 8 of the Constitution. Otherwise, the first general provisions part would be put in doubt. The act that is unconstitutional cannot regulate social relations, and I thus quoted from one of the esteemed justices of the Supreme Court. So, and it actually puts in doubt the qualification of such decisions as those which are taken in exclusive circumstances, and it relates to the notion of the new circumstances. In its nature, compensation is compensatory and it should seek to restore the position of the subject worsened by the violation of the right. It's restitutio in integrum right. And I do agree that the purpose of Part 3 of Article 155 to ensure that the restoration of the violated right of a person due to constitutional injustice committed against him or her deserves support. And again, I quoted from one of the esteemed justices of the Supreme Court. And Article 10 of the Law on the Execution of Judgments and Application of the Case Law of the European Court of Human Rights, which provides for the mandatory implementation of the principle of restitutio in integrum with a view to restoring, as far as possible, the violated rights of the subject, which involves the re-examination of the case in court. Thus, the requirement for the restitution is the recognition of the violation. But the Constitutional Court does not establish the fact of the violation of the right. It just establishes the unconstitutionality of an act. And the refusal to review the case in such circumstances also means a refusal to compensate for the damage caused, even when the unconstitutionality of the act is known, which means that the right is violated again again, and damage is caused again. The case law and the article of 361 of the Code of Administrative Procedure is reviewed very extensively. The courts would refuse to consider such cases because they say that the principle of res judicata should be complied with, then admissibility of retroactive effect of the SSU decision, and as well as the phrase in clause 1, part 5 of Article 361, which allows review only in the court of decision has not yet been executed.
Стаття 2 і 6 Кодексу адміністративного судочинства. Оскільки виконане рішення суду у разі застосування неконституційного акту ще більш ймовірно порушує права, свободи і інтереси, які адміністративний суд зобов'язаний захищати. Неприйнятною також є вимога переглядати подібні судові рішення, які не передбачають спеціальної процедури виконання. Отже,
decisions that don't have special procedure.
невідповідності
Such reservations are not in line with Article 3 and 8 of Constitution, and also Article 55 of the Constitution that guarantees the right not only to seek protection of the violated right in court, but also to receive such protection. A comparison of paragraph 1 of part 5 of Article 361 with paragraph 3 of the same part, which doesn't contain such a reservation. Although the content of these two paragraphs should be quite similar, is illustrative. It's difficult to explain the absence of analogy. A violation of the Convention on the Protection of Human Rights, which is remedied by reviewing a decision that has entered into force, and as a rule is enforced, cannot be considered more serious than a violation of the Constitution of Ukraine, which for some reason is not allowed to be remedied in the case of enforcement of a court decision. The statement about retroactivity of decision of Constitutional Court seems to be based on a false analogy with the application of a rule that was in force at the time disputed legal relationship. Retroactivity aspect is based on erroneous analogy, using the version of the law that was valid at the time in use, but time was cancelled or changed by legislature. The last argument removes in case that this law was valid at that time, at that moment, was not important. Important was whether it was constitutional and it was used lawfully. So-called retroactive action of the Constitutional Court. In case that it's lost, it's an retroactive effect decision. Part 3 of Article 7 of Code of Administrative Procedure absorbs both cases where unconstitutionality of legal act has been established and the case when the court comes to conclusion the act is unconstitutional. The modus imperative covers the law that was effective, but whose unconstitutionality was established. That denies presumption of constitutionality of the law, which is natural for executive authority, but not be applied in administration of justice. Res judicata, as a ground for refusal to review a decided case due to the recognition of the applied act as unconstitutional. Obviously, in such a situation, there is a conflict between these principles and the principle of res judicata, which should be resolved by weighing the context of the relevant situation. The example of such weighing is the position of European Court of Human Rights, which indicated the possibility of derogation from res judicata in the presence of special and unsurmountable circumstances. And this against Ukraine. in condition, Spanish Commission ruled that the possibility of reviewing final court decision on indisputable grounds of public interest doesn't contradict the principle of legal certainty. Such grounds include the need to comply with constitutional principles, which are more important situations. In resolving the conflict and principle res judicata, the other, by means of their relative weight, you should give preference to Articles 3 and 8 of the Constitution, which refer to the general principle constitutional order of Ukraine. Legal certainty for abiding Constitution is more important than certainty of a particular decision. Otherwise, res judicata principle, that means res judicata pro veritate habetur, the decision in the case is considered true, loses its meaning.
Слід погодитися, що відшкодування внаслідок визнання
We
права
should
порушення
agree
може бути застосовано до минулого
that
за певних
it
умов.
could be used to the
Справедливої
past
рівності як
under
коригуючої
certain
норми, з
circumstances.
дотриманням необхідного балансу між будь-якими
Equality,
несприятливими
keep a
наслідками для прав, свобод і
necessary
інтересів
balance
особи і цілями
between
на досягнення, які спрямовані
consequences
оскаржене
and
рішення
the
чи дія,
goals
наприклад,
of
правами та
that
свободами
they want to
інших осіб
achieve,
чи
rights
іншого
and
публічного
freedoms of
інтересу.
other persons
Однак
or
подібна
other
оцінка
public
може бути
interests.
здійснена
But
судом
such
лише
assessment
при
could be made by
перегляді
court
справи
only
по
when
суті,
reviewing
а
the
без
case
перегляду
on
оцінити
merit.
це неможливо.
Without
Проведення
review, it's
міркування
impossible
дозволяє
to
дійти
assess
таких
it.
висновків.
That allows to
По-перше,
come to
підстава для
such
відшкодування в умовах статті
conclusions.
152 Конституції
First,
пов'язана з фактом
grounds written
неконституційності
in Article
застосованого акту, який
152 of
визнається,
the
але не створюється
Constitution
Конституційним
are
судом.
connected
Цей
with
факт об'єктивно існує як
constitutionality,
ex
which is
tunc, і не
recognized.
пов'язується з
It
дією
exists
рішень
in its
Конституційного
tunc.
суду
It's
вчасно.
not connected
Тому
with
встановлення
decision
судом,
Constitutional Court in time.
неконституційності акту, застосованого
Establishing
судом
of
при вирішенні справи, має
unconstitutionality
ознаки
of the
невиключених
act
аналогічних
has
обставин.
signs of
Друге,
related
відшкодування має
circumstances.
ґрунтуватися на
Second,
встановленні факту
compensation
порушення
should be
права
based on the
застосуванням неконституційного акту.
established
Без
fact of
порушення
violation
права
of the right.
шкода не
Without
може бути
violation
завдана.
of the right,
Це можливо лише шляхом перегляду
damage
відповідного
cannot be
судового
incurred. It
рішення,
could be
незалежно
done
від того, чи
by
було воно
reviewing
визнано.
of court decision,
Обмеження перегляду
irrespective of
умови, якщо
fact
рішення
whether it
ще не
was
виконане,
enforced.
має ознаки неконституційності.
Limitations
І тому,
are
мені здається, могло би
unconstitutional
не
if it's
застосовуватися
not
судами на
enforced
підставі
yet.
статті 7
It could
Кодексу
not
адміністративного
be
судочинства.
used by
Оскільки воно
courts
суперечить
based on
принципові
Article
верховенства
7
Конституції.
of
Принцип
Code
res judicata в такій
Administrative Justice.
ситуації
Principle
має
res
уступити
judicata
принципу поваги до прав
because it
свобод
must
людини та
give
вимозі
way
їх
to
гарантій,
principle
які
of
визначають
protection of
зміст та
rights and
спрямованість
freedoms that
діяльності
define
держави.
the content
Третє.
and direction of action.
Відшкодування
And
повинно
third,
передбачати тою
compensation
мірою, наскільки
should
це можливо,
provide to an
реституцію
extent
інтегру.
possible
Ступінь
restitution
можливості
in
відновлення
integra.
порушеного права має бути
The
оцінений судом при
degree
перегляді конкретної
of
справи з
assessment
врахуванням
should be
усіх
taken into
обставин і
account by
факторів.
court,
Джерела,
taking
але
into
не
account
обсяг
all
матеріальної компенсації
circumstances
дійсно
and
повинні бути
facts.
встановлені законом.
Sources should be established by law.
Тут існують
However,
інші варіанти
here
вирішення
there
проблем,
are other
які не
options of
зв'язують
resolving
суд при
problems
прийнятті
that
відповідного
do
рішення.
not oblige
Дякую дуже
court
за увагу.
making certain decisions. Thank you for your attention.
Я запрошую Славіцу Баніч.
Now
наша
I
міжнародна
invite
експерт та постійна учасниця
Slavica
наших,
Banic, our
практичних
expert,
семінарів.
permanent
Славіця Баніч
participant of
міжнародний
our
консультант Ради
seminar.
Європи,
She is
міжнародної
international
консультації, суддя Конституційного
consultant
суду
of Council
Хорватії,
of Europe
Федерації,
from
екс-заступник члена
Croatia,
Європейської комісії за демократію через право,
retired judge,
Венеційської комісії.
ex-member of Venice Commission, and just our good friend of Ukraine. Madam Banic, the floor is yours, please.
Дякую. Доброго дня. Вітаю вас усіх.
Thank you. Good afternoon. I welcome you all.
Thank you very much for inviting me to be a part of this international seminar. And it was a challenge to share with you the Croatian experience with regard to the issue of compensation of damage for the unconstitutional acts. So Croatian and Ukrainian constitutions have many common features in striving to shape the democratic society based on the rule of law and protection of human rights and freedoms. Among them, for the purpose of this presentation, is the power of the Constitutional Court in both countries to decide on issues of compliance with constitution of laws and other legal regulation. Still, they differ in relation to the institution of proceedings for constitutional review, as well as they differ in the aspect of the compensation of damage in the case of established unconstitutionality. Unlike Ukrainian constitution, the Croatian constitution does not foresee obligation of the state to compensate the pecuniary or non-pecuniary damage inflicted on individuals or legal entities by the unconstitutional acts, nor it contains the provision for such regulation to be regulated by law as it is provided by the Article 152 of the Ukrainian Constitution. Still, the compensation of damage as a remedy for violation of rights caused by the unconstitutional law or other regulation exists. Since in Croatia, and this is the difference between Ukrainian constitution and Croatian one, everyone can lodge the proposal for the constitutional review of the law or another regulation, independently from the constitutional complaint which is filed against individual acts. If the court accepts the proposal and abolishes the disputed law or another regulation as unconstitutional, the individual or legal entity who proposed the review is entitled to request the change of the individual act that is based on the law or other regulation declared as unconstitutional or illegal. Only in the case if the change of the individual legal act cannot redress damaging effects of the violated right caused by the unconstitutional law or regulation, the compensation of damage can be required before the competent court under the rules of the tort law. As it can be seen, there is no automatic right to compensation, nor there is sufficient legal certainty whether the compensation of damage will be awarded by the courts at all. So general liability of the Croatian state does not exist in spite of the fact that unconstitutional acts could infringe the very essence of certain rights. However, this conditionally said void in the Croatian legal order has been filled up by the practice of the Constitutional Court, which approached to this issue on the basis of the principle of justice and by relying on the doctrine of fair balance developed by the European Court of Human Rights in its case law. The rationale of the fair balance principle, according to the European Court, is to provide effective protection of fundamental human rights and offer to states considerable possibilities for regulating the exercise of these rights. So the Convention therefore implies a just balance between the protection of the general interest of the community and the respect due to the fundamental human rights while attaching particular importance to the latter. A landmark, I thought it would be the best to show you actually how did the court, how Constitutional Court did this. So a landmark case in this field presents the decision of the Constitutional Court from 2013 related to the law on public bailiffs. In short, in 2010, Croatian Parliament enacted the law on public bailiffs and postponed its enforcement twice. Although implementation of the law was postponed, Ministry of Justice conducted a number of trainings sessions for future bailiffs, organized the exams for bailiffs, and in 2011, it appointed 71 bailiffs, all with purpose to smoothly organize institution of public bailiff for the work once the law is enforced. However, during the second postponement of the law, the Parliament suddenly invalidated the law by the law on termination of validity of the law on public bailiffs and declared the cease of the service of the appointed bailiffs. So the large number of bailiffs filed proposals to the Constitutional Court for the review, constitutional review, and speaking in simple language, their situation appeared bizarre. They were appointed bailiffs, but have never practiced the service because of double postponement of the laws, and suddenly, by force of the law, their appointments became ineffective and they were as service invalidated. So what about the court? The court rejected the constitutional review of the law because procedural requirements to the review of the law in merit did not exist anymore. However, the court in this case did not act formalistically and put aside this case. On the contrary, bearing in mind that it were the bailiffs who proposed the review and the objections actually expressed in the proposals, the court focused on their legal position. It realized that appointment required from bailiffs to leave the current job, to ensure the premises and equipment necessary to conduct the service. And in their proposals, they emphasized also that they were exposed to completely legally uncertain situations, since the legislator did neither regulate their status after invalidation of the law and respectively their dismissal, nor is said a word about the pecuniary or non-pecuniary damage they suffered. So starting from the point that the legislator is free to choose the model of legal enforcement, which will be the best, which will best reflect the legal aim, the court deemed that discretionary powers of the state must not, however, entail consequences that disagree with fundamental constitutional values on which the constitutional order of the Republic of Croatia is built. So, requirements of the rule of law, by the opinion of the court, dictate that in the circumstances that existed in the case of public bailiff service, systemic legislative changes should be implemented in accordance with the principle of fair balance, with as few consequences as possible for those who will be affected by these changes. In connection to the latter, the court emphasized that by abolishing the bailiff service, legislator did not provide any administrative or any other judicial protection of the rights of these dismissed public bailiffs that stemmed from the individual decisions of the Ministry of Justice who appointed them. So the task of the court was to determine whether the legislator managed to achieve a fair balance between the change in the legislative model of enforcement and the protection of the individual interests of the appointed public bailiffs. In weighing of these two confronted interests, the court started with statements that even if the legislator had recognized by the law the civil lawsuits for compensation of damage, such approach would not be acceptable from the point of the protection of constitutional rights, because in this very case it was not just a matter of mere compensation of damage, but it was a matter of violation of bailiffs' legitimate expectations based on valid legal acts, and at the same time about the trust of individuals in the institutions of the state and law that these institutions create. So the legislator justified invalidation of the law as contribution to the larger legal certainty and rule of law as ideals of modern and social states. So you can imagine about this. So the Constitutional Court considered that in the eyes of bailiffs, the way the law was invalidated, actually legislator violated these ideals and values. So by the court, legislators' ignorance to establish the fair balance between the interest to abolish the service of bailiffs and protect the rights of bailiffs is not acceptable in democratic state based on the rule of law and the protection of human rights. So such approach violates principle of legal certainty, legal predictability, and to the detriment of individuals, no matter how significant the public or general interest opposed to them may be. So additionally, such legislative practice inevitably reduces the public trust in the state's legal system and thus further endangers the rule of law, the fundamental constitutional value of the Croatian legal order. Since the actions of the legislator towards the appointed bailiffs were of such nature and intensity that required appropriate and different solutions in order to establish a fair balance, for each of 71 appointed bailiffs, the court decided that they ought to be granted a special monetary satisfaction in a lump sum of 2,500 euros. The court declared that respect of the rule of law is the only way to maintain public trust in state and public institutions. So the granted satisfaction was not just satisfaction or compensation of damage, but satisfaction actually that serves the purpose of maintaining this trust. So the power to grant satisfaction, the court actually found in its provision in the Constitutional Act of the Constitutional Court that the court may determine the manner in which the decision respective its ruling will be executed. However, the court emphasized that this satisfaction is an independent obligation of the state and does not affect general right of appointed bailiffs to claim compensation for damages suffered in court proceedings according to the general rules of tort law. The court said that monetary satisfaction is granted is based on the principle of fairness that permeates the entire text of the Constitution and is inherent in the area of the protection of human rights. So after this decision, dismissed bailiffs actually successfully instituted the court proceedings before ordinary courts according to the law on obligations, claiming different kinds of damages, mainly I think the damage on the loss of profit, so which they suffered, and they were very successful in these claims. So with the reference of the Professor Mulberry's view that at least two discrete functions are performed by the fair balance principle, first, that concerns the proportionality of the state's conduct, and second, to provide a mechanism enabling the court to determine if the state is subject to an implied positive obligation arising under the convention or constitution, it can be freely said that both of these functions found its place in a reviewed court's decision, establishing thus the standard of the necessary requirements in the legislative decision-making process. So for this rule of law and protecting of constitutional devastating legislative action is not the only one in the practice of the Constitutional Court. Just briefly to mention you, the court also granted the monetary satisfaction to the citizen who objected in effectiveness of the state because the bylaw, which should have clarified the terms and conditions under which the legal right to change the sex could be executed, was not enforced. Such inactivity of executive bodies made valid legal norms actually ineffective, and the recognized rights were pure theoretical. Because of unjustified length of deciding on the case, because of non-existing of the ordinance that would clarify these terms, the court found the violation of the right to a trial within reasonable time in connection with violation of the right to respect a private life, stating that legal right to change the sex must include the age of the applicant and importance which such proceedings have for his future physical development and stability, as well as formation of his personality. In a number of other cases, which were mainly based on the constitutional complaints, as actually Nyatowski actually mentioned, the court used the fair balance principle to ensure that interests of states are not protected to the detriment of the rights of the individual. Speaking of these other indemnities, an important decision of the court is the one where the court declared that its decision on abolishment of the law could not be implemented in a way to secure the acceptable level of the protection of human rights. Namely, the court observed that omission of the state to enable the true implementation of the court's decision related to the abolishment of the law on tenancy rights brought the applicant to the unbearable state that the lady was in the issue could not acquire the right to apartment. So for that reason, the court deemed that it is the obligation of the state to repair her personal situation in a way to enable her to use another apartment and not to act for the government contrary to the to that obligation and disable the implementation of its decision. So such state actions, by the opinion of the court, lead to legal uncertainty and undermine the trust which citizens should have in functioning of the state. So for these reasons, the court obliged the government of the Republic of Croatia to ensure the removal of negative effects of the state in which the applicant came in a way to secure the use of another adequate apartments. So to conclude, in the absence of the rules related to the compensation of damage caused by the unconstitutional laws or other regulation, the Constitutional Court of Croatia found a way around that problem by recognizing that monetary satisfaction, or rather indemnity, as you see, serves the purpose of strengthening the rule of law and deter constitutional violations. As it can be seen from the presented decision, the court firmly relied on the demands of the rule of law as a source of its action, however, also as obligations of institutions to act according to this. I will finish here, and I'm open for your questions, and I thank you for your attention.
Пані Баніч, дякуємо. Залишайтеся з
Thank you
нами.
very much, Ms. Banic. Please stay with us. At the end, we will have a Q&A session by all means. And I would now give the floor to Mr. Norkus. He is Advocate General at the Court of Justice of the European Court, Judge of the General Court of the European Union 2019-2024. Mr. Norkus, could you please share with us the criteria that the General Court of the European Union is guided by when they think about liability for compensation of damages? Thank you very much.
Дякую, Miroslava. I hope you can hear me.
Miroslava.
Dear President Kravchenko, President Smokovich, can you hear me? Yes. Dear colleagues, dear judges, first of all, I must say it is a great pleasure for me to participate at this seminar, to listen to your discussion. The interpretation is marvelous. Thank you to the interpreters. And I'm here to present the European Union perspective on this topic. When I'm saying that it is my pleasure to participate, I'm saying it in my sincere admiration of the commitment of the Ukrainian judiciary, and in particular of its Supreme Court, to upholding the European values, which are also the Ukrainian values, such as the rule of law, while at the same time facing brutal aggression aimed at denying those values. Undoubtedly, the seminar is one of the elements in your process of reflection, how to better protect the rights of individuals guaranteed by the Constitution of Ukraine. However, its findings may also be important in the process of Ukraine's integration into the European Union, as rightly mentioned already by Professor Kozhubra, and at least for one reason. After Ukraine joins the European Union, the rights of individuals arising from the Union law and violated by Ukrainian institutions will be defended before Ukrainian courts as European Union courts, not before the Court of Justice in Luxembourg, where the Supreme Court of Ukraine will have the last word. And now, the European Union law did not establish procedural rules, nor did it establish all substantive rules according to which claims for compensation for damages due to violations of European Union law are examined in national courts. The examination of such claims is left to so-called procedural autonomy of the member states, subject, however, to two important requirements of effectiveness and of equivalence. Effectiveness means that the implementation of rights stemming from European Union law cannot be excessively difficult, in simple terms. Whereas equivalence means that the protection of union rights cannot be less favorable than the protection of purely national rights. Hence, for instance, your procedural rules on evidence, on how damage is to be assessed, and some substantive rules, as much as they are not harmonized at union level, for instance, about the limitation periods for state liability, together with your jurisprudence may have a knock-on effect on the protection of rights stemming from union law. For the time being, however, union law can be seen as a source of inspiration for Ukrainian legal system. And I hope that your enthusiasm towards European Union integration has not diminished due to the recent judgment of the General Court of the EU of 13 November 2024 in the famous trademark case by which the General Court rejected the claim of the State Border Guard Service of Ukraine concerning the registration as an EU trademark of the slogan Russian warship, go F, 4 letters yourself, you know, русский военный корабль, иди куда тебе надо. Moving closer to my topic, I must say that before coming to the Court of Justice of the EU, I was a national judge at the Supreme Court. I also worked at the Supreme Administrative Court. Therefore, I'm fully aware of the relevance of the question. What happens after the Constitutional Court declares an act as unconstitutional? Ideally, the legislator steps in and provides how to remedy violated rights. Unfortunately, it is rarely the case. Can all the persons affected by unconstitutional act claim damages from the state? Under which conditions? In my home country, Lithuania, it happened at least on a few occasions when unconstitutional acts affected a large number of persons. For instance, disproportionate reduction in public servants' salaries was found unconstitutional by the Constitutional Court, as well as freezing of pensions due to economic crisis. In all these cases, thousands of claims for damages against the state were introduced before administrative courts after judgments of the Constitutional Court. The Supreme Administrative Court, however, requalified the actions for state liability due to unconstitutional law into claims for unpaid salary or claims for unpaid pensions. So technically, the question for state liability was not resolved in these cases, as the court found another way to satisfy monetary claims. The state liability for unconstitutional acts as such was, however, confirmed and now is firmly established in our case law. Now, to the substance of the EU law in the matter. The liability for damages caused by an infringement of European Union law is one of the essential pillars, and I mean it, it's one of the essential pillars on which the EU legal system is founded, together with the primacy and the direct effect of the EU law. Primacy, direct effect, compensation for damages. 3 pillars. Depending on the type of act and on the area of its application, union acts can be implemented either in a centralized way by union institutions or, as in most cases, by its member states. This implementation usually requires the adoption of legislative acts by national parliaments. If these parliaments act unlawfully by breaching union law, for instance, by wrongly implementing a directive or not implementing at all, member states may cause prejudice to individuals, for which they can be held liable under union law. The doctrine of state liability for breaches of union law is not explicitly mentioned in the treaties of the European Union, but was developed by the EU courts since 1991 in the well-known case Frankovic versus Italy. You probably heard about the case. There was the Insolvency Protection Directive, by which EU member states were expected to enact provisions in their national law to provide for a minimum level of insurance for employees who had wages unpaid if their employer went bankrupt. Mr. Frankovic's employer went bankrupt, left him with unpaid wage. The directive was meant to be implemented by 1983 in Italy, but 5 years later, they had been paid nothing since there was no money left. They brought a claim against the Italian state, arguing that it must pay damages to compensate for their losses on account of a failure of Italy to implement the European Union directive. The Court of Justice held that the principle whereby a state must be liable for damage caused to individuals as a result of breach of community law, as it was then called, now it's union law, and for which the state can be held responsible, is inherent in the system of the treaty. So it's an element of the system of the treaty. The full effectiveness of union rules would be impaired, and the protection of the rights which they grant would be weakened if individuals were unable to obtain redress when their rights are infringed by a breach of community law for which a member state can be held responsible. The principle of state liability has been later developed in other landmark cases such as Brasserie, in which the Court of Justice confirmed the same principle of state liability for breaches of union law, even if there was the national parliament who passed the statute. Or Köbler case, in which state liability was confirmed for breaches of union law committed by last instance national courts. They can also breach union law by wrongly interpreting it. So from the point of view of union law, it is completely irrelevant which state institution or body is at the origin of the infringement. It is, however, not only member states which can breach union law. The union institutions themselves can act illegally by adopting a legislative act which violates primary EU law, or by incorrectly implementing a legislative measure. Actions for damages against the union on the one hand, and state liability of member states on the other hand, are two separate mechanisms by which compensation for infringement of individual rights may be sought, depending on who is at the origin of the infringement. Nevertheless, they constitute two sides of the same coin in ensuring the protection of the individual's rights. Moreover, the conditions for state liability and the union liability are practically identical, and the case law also has developed harmoniously. Although the European Union does not have a constitution stricto sensu, its founding treaties, together with the Charter of Fundamental Rights and general principles of EU law, fulfill a similar role to that which national constitutions play in individual states. Unlike in Ukraine, the Union's legal order does not contain a provision comparable to Article 152, paragraph 3 of Ukraine's constitution, which specifically addresses the compensation for material or moral damages caused by laws that have been declared unconstitutional. Instead, the union law provides one universal legal basis for union liability, which applies irrespective of whether damage was caused by a legislative act, a regulatory act, or by an act of individual application. According to Article 340 of the Treaty on the Functioning of the European Union, and I quote there, "In the case of non-contractual liability, the Union shall, in accordance with the general principles common to the laws of the member states, make good any damage caused by its institutions or by its servants in the performance of their duties." A similar provision is laid down in Article 41 of the Charter of Fundamental Rights. And such claims against the Union are heard by the General Court of the EU upon appeal by the Court of Justice of the EU. The European Union legal order is autonomous. Autonomy is a big word in the European Union. It is autonomous also from the national legal orders. And therefore, European Union courts have drawn on these, what I mentioned, general principles common to the laws of the member states purely as a source of inspiration in the development of an independent union law on non-contractual liability. Consequently, early on in the case law, the Court of Justice proclaimed that the non-contractual liability of union presupposes the existence of a set of circumstances comprising actual damage, causal link between the damage, and the illegality of such conduct. I think these conditions are identical in every legal order of the European Union. And since the assessment of damage and causation does not differ greatly from the assessment carried out in the most legal orders, I will only briefly share a few thoughts on the condition of the illegality of the act as it is applied by the Union Court. In the landmark judgment Bergadem, the court held that the Union law confers a right to reparation where three conditions are met. The rule of law infringed must be intended to confer rights on individuals. The breach must be sufficiently serious, and there must be a direct causal link between the breach of the obligation resting on the state or of the union and the damage sustained by the injured party. The reasons why European Union or member state institutions do not incur liability for merely any breach of EU law, but only for those which are sufficiently serious, stems from the need to strike a balance between the protection of individuals against the unlawful conduct of EU or member state institutions on the one hand, and the leeway that must be accorded to those institutions in order to not paralyze their action on the other hand. As to the assessment of whether a breach is sufficiently serious, the general or individual nature of the Union Act is not a decisive criterion. Instead, the departure point of analysis is the degree of discretion afforded to the institution in the case at hand. Where the Union's institution discretion is considerably reduced or even non-existent, a mere infringement of Union law may be sufficient to establish the existence of a sufficiently serious breach. However, if the margin of discretion is large, the breach would only be sufficiently serious if the institution manifestly and gravely disregarded the limits placed on its discretion. And then other factors would have to be present in order to establish a sufficiently serious breach of Union law. Consequently, even where the infringed rule leaves the EU authority reduced or no discretion at all, the existence of a sufficiently serious breach will only be established where, upon examination of all circumstances surrounding the infringement, there are no other relevant factors present that would make it possible to find that the breach was not manifest or not serious. By assessing the margin of the discretion, the court uses case-by-case analysis. For the most part, discretion is considered to be conferred where the provision of union law requires the institution to make a policy choice, in particular where there is a need to reconcile divergent interests. There are also other factors which may be taken into account while assessing the seriousness of the breach. The nature of the rule breach, whether it's a clear rule or imprecise rule, whether the rule is not clear, that might excuse the breach. On the other hand, the fact that the breach was deliberate or that the breach persisted despite a judgment finding the infringement in question, or despite the settled case law of the Court of Justice on the matter, these are factors which would lead to the conclusion that the breach was sufficiently serious. I'm concluding by saying that there is no objective, let alone automatic union liability, no matter how regrettable, how injurious the unlawfulness may be. Instead, the union courts have always strived to establish a fair balance of which other experts, Madam Banic already spoke, a balance between the protection of individual rights and the corresponding impairment of union activity, leaving the union institutions sufficient leeway to fulfill their statutory requirements in the general interest. I thank you for your attention.
Норкусе, дякуємо. Залишайтеся поки що з нами.
Norkus, thank you very much. Could you please stay with us? And to end, we have got the last speaker in this panel. It would be Sergei Riznik. He's Justice of the Constitutional Court of Ukraine and a Doctor of Law, and he will be speaking about the approaches that Ukrainian Constitutional Court is applying in its practices and case law. Thank you very much, Miroslava. Thank you very much for inviting me to talk to this esteemed audience of professionals, people who deal with the resolution of this issue, not only in theory, but in everyday practice. I would be analyzing the situation from the perspective of the constitutional jurisdiction. Even though quite recently I joined the team of the Constitutional Court, I haven't lost a lot in this very issue because the law enforcement practice of Part 3, Article 152 at the level of the Constitutional Court is fairly scarce, as my colleagues have mentioned. Another caveat that I would like to make, since we are considering a number of constitutional complaints about the constitutionality of Article 361 of the Code of Administrative Procedure and Article 120 of the Code of Economic Procedure, quite recently those complaints were merged, and I am part of the Senate to address these complaints, so I am restrained in totally and frankly expressing my opinion. And now, due to some issues with the quorum in the Constitutional Court and impending or imminent issues, I want to be perceived as totally unbiased and objective, so I would be very brief and speak only within the frameworks of the effective legislation. So I practically agree with all of the previous speakers, even though not of their opinions coincided. It might seem paradoxical, but the nature of the issue is also paradoxical. And the language of Part 3 of Article 152 dates back to 1996, and we didn't even heard at that time about the constitutional complaint, but the issue did exist. And as the ex-justice of the Constitutional Court admitted, they had at that time to address the issue of compensation of damage, not based on the constitutional complaint and not in the cases of individuals who already had some litigations pending. And now these issues have been exacerbated, and if we focus on the opportunities to resolve this matter, then it's not only the honors of the Constitutional Court, but also that of the broad range of stakeholders when it comes to the constitutionality of certain acts of legislation. And I've always said that as matters stand, we cannot be speaking about the Constitutional Court of Ukraine as the only body of constitutional jurisdiction. We are the body of the final constitutional review. It's only on us to recognize a certain act as unconstitutional, but there are also administrative courts that have to enforce the principle of the rule of law, and I call it an interim judicial review because they can or they have this discretion not to apply the act that is deemed unconstitutional. But we cannot expect the regional court judge to always understand it, and when it comes because they've got this plethora of absolutely varied cases, and sometimes it takes years to consider the cases related to the compensation of damage. And when there is a conviction that the act is truly unconstitutional, then the situation would improve if courts and judges were braver in refusing to apply the unconstitutional act. And they could then seek guidance from the Supreme Court, and the Supreme Court can talk to the Constitutional Court. And you say that the Constitutional Court sometimes takes years to take its ruling on constitutionality or unconstitutionality on a certain act. So, but for this, the price of this matter would not have been this high. So if the courts considered their cases more timely and those cases came to the Supreme Court, and we could actually consider constitutional complaint speedier, then I think the situation would have been different. So as I said, the language of the Constitution, particularly when it comes to Article 152, is that of 1996, and until 2009, the Constitutional Court never recollected this part of the Constitution. And it was in 2009 when the referral was made to Article 152, the positive obligation of the state is to adopt an act that would define the procedure and mechanism for the compensation of the damage. And later in 2021, the Constitutional Court reiterated this ruling, and in 2023 there was another ruling on the merits in the Senate, and this issue was raised yet again. And in each of the latter rulings there was a reference to the ruling of 2009. And the court, in the case of Mr. Dyachenko, that the state is obligated to develop the procedure and legal mechanism for the compensation of damage incurred by those individuals through the unconstitutionality of the act. And the citizens of Ukraine, to be covered by this law, will be entitled to the compensation of damage that they suffered because of the validity of Part 3 or Article 152 of the Constitution of Ukraine. And I will quote from another ruling for you to appreciate the position of the Constitutional Court, again, in the circumstances of the war and in the circumstances of this legal situation. You know, the law does not become unconstitutional overnight, right? So if it had been so, we would be very similar to the Russian Federation and a very poor misunderstanding of the principle dura lex sed lex. And within our judicial system, we have to be very thorough, and this system should operate properly, and we should be looking for solutions. So the ruling of 2021 that I mentioned before, and I wouldn't be commenting on it, of course, because I wasn't part of that ruling in the making. In order to protect the rights and interests, bear with me, of the complainant, the court ruled that it does not cover the legal relations that were valid before the ruling was taken. And the Constitutional Court believes that a citizen has a guaranteed right for the compensation of moral and material damage incurred due to the application of the unconstitutional law to them. Yes, this is a well-known case. It's the case of the constitutional complaint by Bivalkevich Bogdan. It was about the law on the national police, whereby the law provided for the dismissal of a large number of the police force and the hiring of the new national police of Ukraine. The interest of the national level, the establishment of the new police force was understandable, but the police officer thought that they could be compensated when it came to the material damage, but the Constitutional Court did not rule that he should be reinstated in his position. So it was about Article 55 and 56 and the right to fair trial, and the Constitutional Court eventually stated within its prerogative to point to the procedure of the decision-taking. And I would reiterate that this ruling did not cover the decisions taken once the ruling was pronounced. Yeah, so the court just confirmed what we are discussing. At the same time, the court opted for a very unusual formula, should I say. And it was an attempt for the Constitutional Court to address this issue anyway. Another interesting case under the Constitutional Court of Vasylenko, it's a very recent case, 2023. The Constitutional Court has repeatedly stated that the law should be put in place and that the individual has the right to the compensation of damage if an act that caused the damage is deemed non-constitutional.
Якщо треба буде, то я скажу, хто це.
If necessary, I will tell who that the Constitutional Court in this judgment did not indicate whether the procedure of compensation for moral or material damage incurred to persons by unconstitutional acts is not specified, or whether there was a legislative act, because they have the right to decide individually on that. At this stage, I cannot say that I agree with that, but lengthy ignoring by set of authorities what is written in Article 152 can give the grounds for constitutional courts to act proactively to ensure effectiveness of this constitutional prescription. This is all practice in essence. On the one hand, it makes the problem of this legislative gap more acute. While developing this practice, Constitutional Court went even further to develop this doctrine. While separating the concept of legislative omission and legislative gap. This doctrine requires further development. When talking about legislative omission, there is certain regulation, but with deficiencies. The court can procedurally recognize this omission. Second, when there is a gap, absence of legislative regulation, the court cannot substitute legislative authority and has no procedural instruments to recognize this gap unconstitutional. Talking about our case, whether we can believe, at least hypothetically, at least partially, these procedural norms of the code that at least partially establish the possibility to indemnate the moral damage. You can speak about normative omission and include into the judgment of the court. I cannot further develop this thought, will not make further quotations, but there were several refusals with reference to Article 1175 of Civil Code. There is such a practice, not apply this provision in case when law is recognized unconstitutional. If these norms were not applied in the final judgment, there were no formal grounds to open proceedings according to the law on constitutional court. When I give such examples, it doesn't mean that I approve them, that I am morally or materially responsible for that, but such practice does exist, and I'm quite convinced that as long as system of safeguards is not functioning in full, and each element of this system does not fulfill its function, as long as the law is not adopted on compensation of moral and material damage, and the mechanism regarding exceptional circumstances is not approved, we, even jointly, Constitutional and Supreme Court, it will be difficult for us to resolve it, but at least we can reduce it, at least take into account challenges of martial law, and have the right to establish constitutionality or not constitutionality. We talk not about validity, but also effectively and applicability in particular cases. There are three different things, that three processes that we can operate by establishing fact of unconstitutionality, as mentioned today. The remedies that could be used by Constitutional Court, postponement of loss of validity by the Act, continuation of validity of the Act, paradoxically it sounds, makes less damage than its absence. But you should use these instruments carefully. If we use that act would be called unconstitutionally, but we understand that it must function for some time. Why we respond so abruptly? It should be applied in this circumstances because all other options will cause even worse consequences. But I am not taking any of the positions. I just described existing problems, and I hope that resolve them in the 28th year of its existence. Thank you. Thank you. Moderator. I want to say that we have already time for discussion, but according to the schedule, lunch must be provided. But being a moderator still, but I offer to conduct at least very short discussions, couple of questions that audience surely has. Look what esteemed experts we have. Even our judge from European Court, Mikola Gnatowski, Madam Banich, Tenorkus, Mikhaila Kozubra, Yuri Kluchkovsky, Mr. Riznik. If you have any questions, please, but be brief, please, to have time for the answer. Brief answer. If you want to ask a question to somebody in particular, I have a question to Yuri Kluchkovsky. I'm Sergei Ikonenko from Supreme Court. Thank you for your presentation. It just contained response to one of my questions regarding principles used in this type of dispute. But second question remains, painful question, about subjectivity of parties. When the court is reviewing unconstitutionality, who is mentioned? Verkhovna Rada and Cabinet of Ministers. As regards persons who will be the complainant about unconstitutionality. In legal community, there are several opinions regarding such subject. Who can do it? A. All individuals regarding whom regulatory act was covering that later was recognized unconstitutional. B. Persons who asked for protection of this right and general court used this unconstitutional act. And thirdly, subjects that used exclusive right for constitutional complaint. Only they are entitled to get such a compensation. My question is, what's your opinion of that? Who are respondents? Take into account subjects of legislative initiatives, and who has the right to protect its damaged rights? Thank you for your question. Try to be brief, but not very brief. Who can be responded? Our old history gives example when there were massive non-payment of salaries in budgetary institutions. These budgetary institutions themselves were not to blame. Budget custodians were responsible for that, but I don't see other way to resolve it. Those who applied unconstitutional act, even not knowing that it is unconstitutional, this state body will have to respond, and there will be regressive payments, but that pertains not to a particular individual. These are problems in a state relation. Who can ask for compensation? There is a temptation. Call Constitutional Court the fourth instance and give this compensation only to those who apply to Constitutional Court. And in some countries, there is a award for those who come to Constitutional Court. Try to protect the interest of society. Seems to me that we must realize if there is a violated right, each and every person whose right violated has the right to get compensation. Will that be a lot of money? Not much money. The states at least will start thinking about maybe its parliament, while making unconstitutional law, will be more responsible. Or other steps should be made to make such situation that unconstitutional acts are not adopted so frequently. Maybe our international experts would like to add something from their experience or practice in your countries. No? Then thank you. Who else would like to ask questions? Please. Good afternoon. Judge of Cassation Court Rogac. My question is simple, but I want to get the answer. Now, in practice of Constitutional Court of Human Rights, I'm a practicing judge, and therefore I ask it. When a certain law is recognized unconstitutional, but it is mentioned that this norm will become ineffective 6 months later, when this norm is continued being used by state authority, the Ministry of Justice that applied these norms recognized unconstitutional for a certain time. My question is, what's your opinion? What are the consequences of recognition of the law unconstitutional? And what is happening within next 6 months? It's a question to everybody. I will start. I partially mentioned that. I mentioned this remedy. Constitutional Court is still in the procedure of formulating testing criteria for application of it. But quite often happens, especially in conditions of martial law. The main problem is from courts that on the one hand they have Article 8 of Constitution, direct action, the duty to apply a regulatory act, which was already recognized in Constitution. On the other hand, postponement of loss of validity by this act, and the judge doesn't understand. Is that a signal that act is unconstitutional, so don't use it, although 6 months remain? Or if for some reasons court decided to continue it, this is issue of legal uncertainty caused by this instrument, and I hope that quite soon the court in one of its judgments, when substantive part, will give answers. Mr. Klitschkowski, I touched this issue a little in presentation. Please try to answer to you yourself whether the Constitutional Court has the power to allow to use the law that is not in compliance with Constitution. If they don't have such power, then let us openly say, Part 2, Article 152 is contrary to Chapter 1 of Constitution. It is unconstitutional. And Constitutional Court, but making a judgment, did not notice it. When talking about observance of rights or infringement of rights, there could not be action of unconstitutional court. Theoretically, it can arise. Practically, it can arise. And nobody's rights are not violated. that pertains to procedure activity of certain state body, that is pure procedural norms, or what Mikola Kazubra said, when unconstitutional law is unconstitutional not by substance, but by procedure of adoption. But there are no problems in substance. You can suppose it, but honestly speaking, abuse of the right to allow to violate Constitution. Constitutional Court doesn't have this right. I agree. One sentence. The only example when social payment is established by law in the amount that violates constitutional parameters. But in case it is recognized unconstitutional, person will not get any payment within certain time. Classical example.
I do not agree with Mr. Klitschkowski at all, because it will lead to the legal naturalism, and even then every person will be assessing whether the law complies with the Constitution. The Constitutional Court stated that the presumption of constitutionality should be enforced at every time to prevent chaos. Then, as far as the postponement is concerned, the Constitutional Court assesses the implications of non-constitutionality when they establish this period for postponement. And those implications can be much more serious in certain circumstances. Then a question from me: why do we think that Article 152 Part 3 establishes the right to compensation and has direct action? If you look at that very closely, it will be about establishing or defining competencies or authority. The Constitutional Court is entitled to address all issues related to constitutionality or non-constitutionality, including enforcement and compensation. But Part 3, Article 152, removes that from the Constitutional Court's authority and moves that into the purview of other courts. So we should look at whether there is special or general law that would fall under this Constitutional Court. I agree with Mr. Kazubra that there are various grounds for this. It can be substantive, it can be procedural, if rights are violated or if certain principles are violated. Okay, could you stop here, because we have to continue this discussion later.
Я перепрошую, Олександр, ви мені вибачте, ви завершите.
Alexander, sorry, just we also have Ms. Banic, and there are two very important things that you focused your attention on. Two criteria that's a violation of the or a non-conformity with the Constitution. If the Constitutional Court deems certain non-constitutional for procedural reasons or because the Parliament exceeded its powers, then in this case, will there be a right to compensation for individuals? Now that we are discussing it, we bring together various cases that should be separated, right? In the case of Constitutional Court, there is Article 55, and in other cases, when a person goes to court, gets the court decision, in a different case, perhaps, with the constitutional, say, submission, will that individual get the right to compensation? Thank you very much. I'll have to stop you here. Ms. Bernard, you wanted to say something. Is that so? You raised your hand. Is it to agree with something or to say something?
Yes, thank you very much. I will just slightly refer to the issue of the question that came about the respondents and about the comment of Professor Klitschkowski who actually would be entitled, as I could understand, who would be entitled to this compensation. As I will recall again, you know, that in Croatia, as you can see, only those who initiated the proceedings and were successful in this can actually require the change of the legal act. However, if they do not actually remove these negative effects, then they require for the compensation of damage. How actually also dangerous provision in the Constitutional Act, this provision is, I can tell you what happened when we had this a financial crisis in like 2010 or something. The government, the legislator imposed the tax on salaries. And our president of the court actually said publicly that only those who propose actually initiation of the proceedings can require the change of the individual act or compensation of damage, which in practice meant actually that all those who propose the review of the constitutionality can require the change of the acts about the salaries, because the tax was about like 10% on the salary. So what we had at the court situation, we received 110,000 proposals of citizens to review the constitutionality of the tax law, who were actually thinking if the court accepts the proposals and declares, abolishes the law on taxes, they would have the right actually to change the individual act, and they would have the right to return these 10% of the salaries that were deducted. So the court was really in a huge problem. The court actually did not repeal the law. It said actually it was constitutional, but I can only tell you in practice what it can be, what even this norm, which is quite tight, which is out of control of the Constitutional Court and depends very much on the individual, can become also very, very dangerous in the practice. So this was what I wanted to comment to you. Thank you.
Пані Ваніч, тут мені колега підказує, як
Ms. Vanic,
тих осіб, які звертаються.
what do you call the people who apply to the Constitutional Court and when they apply can actually seek compensation? Are they deemed hunters for constitutionality?
Well, in the case of the bailiffs, they were not really hunters, you know. Many times people really propose the initiation because they really want to change the individual act, which is unconstitutional. We didn't have so many problems except this tax law, but only because, you know, the president said it publicly. Actually, it made a kind of stampedo of all those who wanted it. The change. So in a way, it was kind of abused because they expected, you know, that their salaries will be recovered again.
Yeah. Добре, дякуємо за думки.
Thank you for sharing this opinion with us. I think it's time for us to stop here. We do have a lot of opinions, so next year we will address all of these topics in a collection of articles as well as in subsequent events. Now, this would be the end of session 1. We are making any conclusions and we are totally entitled to this approach. So we need some time to digest all of it, to discuss it during the break. And Natalia, when do we have to be back? As the moderator, I will shift the time of the break. Please be back at 1:30 Kyiv time, 12:30 set. Ms. Vanic, Mr. Gnatovsky, all of other people, thanks a lot.